Good afternoon. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call twice a month in which we try to answer the questions that have been posted and, if time permits, answer new questions. Note that all answers are subject to the disclaimers that you would have heard while you were logging in to the community conference. Let me begin first by going over the questions that I have marked as frequently asked questions, which I believe are of genuine interest. So the first question is about what is the rule to recapture H-1B unused time, what is referred to legally as a remainder option, and what if happens if I change professions, employers, etc. So first of all, what is the remainder option rule? This is the way the rule works. Now, you probably all know that H-1B is good for 6 years. After that, you can extend it if you have a green card going or if you have been outside the United States for 1 year. So when you go outside the US for 1 year, you get two choices. Either you can reset your H-1B clock and get all 6 years again, but then you have to go through the lottery. Or you can take the time remaining on your H-1B. That's called the remainder option. So in this example, a community member who has posted this says, I have approximately 4.5 years remaining on my H-1B because they were here on H-1B, stayed only about a year and a half, and then they left to go back to India. He did his master's in chemical engineering. So a couple of questions that I remember reading were, one, can I change my professions and still use remainder option? And the answer is sure, yes. You can go from, for example, being a chemical engineer to an MBA type person, or even in software development if you qualify for that. So even if you change professions, you still can use the remainder option, which means you've got 4.5 years, which you can extend your H-1B, but you're not subject to the lottery. So either reset the clock for 6 years and go through the lottery, or take whatever remains on your H-1B and not have to go through the lottery. That means any employer could apply for you tomorrow, get an extension done or a transfer done of your H-1B even while you're outside the United States, and get you an H-1B, and you could be here in a few weeks. You don't have to wait for the lottery. So the questions specifically are, I did my master's in chemical engineering, then worked for an environmental firm in New York City. My H-1B was approved. I got my H-1B in 2019. Then I moved to India in December 2022, in 2020, and it's been almost 2 years here in India. So I have approximately 4.5 years remaining. Am I eligible to use the remainder option for a different employer under a different field? Yes, you can. I want to know if I can work in the business domain and not in the chemical field. Without commenting on whether that would qualify for H-1B, if you wanted to work in a different domain, that does not stop you from using remainder option. I see no problem there. If I plan to do an MBA, which would be my second master's, is it possible to use the H-1B remainder option for my first semester and work in the business domain? So I'm not sure I understand this question, Anusha, but if you are asking me this, okay, I've got my H-1B remainder, I've come to the United States, I'm working, can I also go to school? Sure, because H-1B does not prohibit you from going to school. So you could work and go to school at the same time. If anyone has a follow-up question on this, press *5 on your phone, please. If anyone has a follow-up question on this. Okay. Let's go on to the next question. And this we have done a few videos on when you get laid off on an H-1B or an L-1A. How does the 60-day grace period work, maintaining status? How do you switch to and back from I-485 EAD? What if priority dates become current but there's no job in hand? So these are all questions we've answered before, but I'll do them all consolidatedly in one place. I'm currently working in the US on H-1B. This is question number 5. Currently working in the US on H-1B, my green card application is pending. I have a 485 EAD approved till 2024 and advanced parole is still pending. Now, what if I get laid off? Since we only have 60 days on H-1B to find a new job, how easy it is to switch to EAD? So switching to EAD is very easy. There is no formal process for it. All you do is when you want to convert from H-1B, or if you have been laid off, you are looking for a job, present your EAD as documentation of your authorization to work. So for example, if you want to discontinue your H-1B, you don't have to have any special magical formulas recited. All you do is you walk over to the HR and tell them, please update my I-9, which is an internal form. Update my I-9 to show that this is my work authorization, not my H-1B. So there's nothing complicated or mysterious about that. It's fairly easy. So the question is, what is the procedure to switch back from EAD to H-1B? And there is only one problem. So when you want to switch to H-1B, the process is you will apply for an H-1B extension, you will get it, but to activate it, you will have to go outside the United States and come back on an H-1B visa if your visa is still valid, or get a new visa and come back. So you'll go to the consulate. What does it involve to switch back from EAD to H-1B? Travel back into the United States with an H-1B visa. And that, of course, comes after you get an H-1B approval from the USCIS. Third question, sub-question within this. Now, if someone switches to EAD and their date becomes current before they can find a job, what are the options? Well, this is a tricky situation, okay? So typically what happens is you don't need a job, you need a job offer. So let's say that I have a company that intends to hire me and I'm not quite yet willing to move. I can take their job offer. But what if my green card gets approved while I'm in between jobs? I think you keep the green card. Why? Because this is a special situation which has not been covered by the regulations. So what I would advise in a case like that, you get your approval, make sure you get the next job in the same or similar field. Keep some documentation that shows they are the same or similar field. Just put it somewhere and forget about it, like in the cloud, so that if at the citizenship stage, if you need that information showing that you've taken the same or similar job as compared to your green card job, even though you did not have it when you got the green card, you should have no issues. This is a hole in the law, and I think you will be all right if you did what I said. Also, the last question is, do we have any info on what the status case remains pending means? Well, I do not know what that means. That could mean a bunch of things. It just simply means it's still under process. Whether that process involves security clearances or there's something else being looked at, or just normal delay that occurs while processing. It doesn't mean anything special. It can mean a bunch of things. Oh, I forgot to check something. I want to make sure you guys can hear me okay.
The conference is now in conversation mode.
Can you guys hear me all right? I forgot to verify.
Yes, we can hear you.
Okay, good. Thank you.
Yes.
Excellent.
Yes. We can hear.
The conference is now in presentation mode.
Thank you. So then comes the next frequently asked question. Now this is another very weird situation. So my H1 is approved. I've got my change of status. And the employer says, well, I can't really take you on board right now. I'll take you on board after a month or 2 months. Well, that's too bad. They have to pay your full salary. That's the law. The law is the employer must start paying your full salary from the date the H-1B is approved or the date you report for duty saying I'm ready to work, so they have to start paying your full salary. There is another leeway for 30, 60 days for employers to take you on board. 60 days if you're in the United States, 30 days if you're coming from outside the United States. But that doesn't operate to absolve the employer from their responsibility to start your payment. If you show up the day after your H-1B is approved, they have to start paying your full salary. So going over the question, they are working to find a suitable project. That's not your problem. They should be really paying you. Is it okay to defer the joining date? So the way this works is, employer cannot stop paying you merely because they don't have a project. That's their problem. This is illegal. Okay. On the other hand, if you say, oh, look, I can't join you for 3 more weeks or 6 more weeks, that's okay. They can accommodate the employee, but they can't keep the employee out of a payroll. Okay. I hope that helps. Star 5 if you have a follow-up question. Star 5. Okay. Let me see if there's there's another frequently asked question. Changing employers after I-140 approval, priority date transfer, I-140 revocation impact. Okay, so there are rules changed on January 17th, 2017. The regulations now say the moment your I-140 is approved, the priority date is your property, not the employer's. It's your property. Okay. So even if the I-140 is revoked the same day, if it was approved, that priority date is yours to keep. You can take it across to any employer. If you go to another employer and if yours is a labor cert based case being filed, you have to redo the PERM, redo the I-140, but you'll carry the old priority date, which is a big advantage. Okay. On the other hand, in the continuity of benefits, let's keep going. So now you have your priority date. In addition to your priority date, if the I-140 remains approved for 180 days, your right to keep extending your H-1B with any employer even after 6 years remains inviolate. They cannot take that right away, even if they revoke your I-140. So if the employer revokes the I-140 after 181 days, not only do you have your priority date to carry forward, that you secured the moment the I-140 was approved, you also have the additional right to keep extending your H-1B with another employer beyond 6 years. Okay? What happens if the employee leaves or gets laid off a month after I-140 approval? Even that is not a problem as long as the I-140 remains approved for 180 days. If they revoke, you still keep your priority date. If they revoke after 180 days, you keep your right to extend H-1B with any employer. Now this part I'm trying to understand what they're asking me. In this case, can new employer use the same priority date? It's not the employer using the priority date, really. It's your priority date. You are using it through the employer's petition. If new employer gets the new one, what happens when employee's H-1 term has finished before the new I-140 approval comes? I already covered that. I'm not sure I understand the rest of your question. If you are here, press star 5 so we can talk about this because I'm not clear about this part. Star 5. Okay. Does anybody have a follow-up question on this? Press star 5 if you do. All right. I think these were all the frequently asked questions. Okay, that's pretty much it. Let's now, there is a follow-up question from area code 832, which is Texas. Okay. Yeah, Texas, go ahead, I can hear you.
Yes, I have a quick question, Rajiv. So this is regarding, this is in context of H-1B layoffs. And so my I-94 currently expires on December 15th. My H-1B extension was approved on November 30th, and my last day of my job is December 2nd, tomorrow. So the problem is I have the receipt number of the extension, but I won't likely get the I-797A because by the time they get the I-797, my employment would end. So will I get 60-day grace period or not? That's my question because
Hang on
my
one second.
extension is approved, but I don't have the I-797.
Yeah, hang on one second. So, what is the rule on the 60-day grace period? The rule is you have the 60 days max or the time remaining on your I-94, whichever is lesser. So if we consider the current approval, you have only till December 15th, that's when your I-94 expires, you won't get 60-day grace period. But because your extension is approved, I don't care whether you have it in hand or not. That's not required. If you have it approved, and it was approved with a new I-94, which is normally the process, you will have 60 days then. Okay?
Got it, but I mean, if I don't have the I-797 in hand, how will I prove
You will get it eventually,
that
right?
my extension was approved?
You will get it, right? Eventually, your company will give it to you.
No, because my employment is ending tomorrow.
Yeah, but you can still
And
stay in touch
the
with.
I-796.
You can still stay in touch with the employer. The I-94 is required to be given to you. The I-94 comes.
See, okay.
Yeah,
So even if the employment has ended,
yeah, they'll give it to you. Why would they
so
want to
it's a
keep it?
tricky situation because the, the extension was approved yesterday, but employment ends tomorrow.
That doesn't matter.
There's only a 2-day period.
Yeah, that doesn't matter. That doesn't matter. You've got an I-94 that goes beyond 60 days. Therefore, you have 60 days grace period.
Just in case they don't give me the I-797,
I would
will
still
the receipt
argue.
number be enough
I
to
would tell
prove?
I will tell the USCIS that look, my extension was approved, but I don't have any proof of it. So therefore, you have access to files. You find out because I don't have it. I think they will still accept that you've got 60-day grace period.
Got it. And one more quick question. So I self-filed the change of status to L2 on November 29th, and the online form I-539, there is a way you can do that, like the individual
Sure.
can go and file online.
Sure, I know.
I-539.
Sure.
I already did that, but the form is very like loose. It has very loose description. Like doesn't specify exactly what it wants. It doesn't say what type of documents it wants. It just asks for proof of relationship to the L1 beneficiary, and that's all it asks for.
So your complaint is the form is too easy.
Would you?
The form is too easy. That's the complaint.
Yes.
It is. It is
That's not a
easy.
complaint. I mean, they usually reject and
No,
on the
no,
basis
no.
of lack of evidence or send RFEs.
Look, the rule in filing any forms with the USCIS is this. Look at the form instructions. It will tell you what is the required evidence. As long as you have put the required evidence, they cannot reject the form. Okay? So there is desired evidence and there is required evidence. As long as you have put down the required evidence, which is listed on the form instructions, you have followed the instructions, they cannot reject your form. Don't worry about it. And actually, that's why I tell a lot of people, you don't need to hire a lawyer to file a form I-539. It's a simple enough form. Some situations are tricky when you need a lawyer, but these forms, some of these forms are quite simple. Okay.
Got it. So would you give any tips like just so they had a section where I could upload any evidence, like any number of files, and it was labeled additional evidence, and it's left to the discretion of the petitioner, which is me in this case. So what additional evidence should I provide them?
Well, I'm not sure. I haven't filled out a form I-539 for 30 years. I don't even know what all it asks, but I can tell you this. whenever you file a Form I-539 as an L2, you will need proof that your wife, your spouse, has an L1, so their L1 approval notice. Maybe some evidence, it's not required, but it's desired, that they are maintaining status. So some pay stubs, 3 or 4 pay stubs, proof of relationship, and that should do it. Those are the 3 most important things. Oh, the 4th thing is that you filed the form while you were still maintaining status. So the proof of your own H1B, your approval notice, as well as your 3 or 4 of your pay stubs. That is what I would submit if I were filing the form.
Got it. So the pay stubs, so by the time they approve it, so let's say they look at it in February of 2023, and I provide the pay stubs as of today, will that work for them?
Yeah,
Because
that's good
it'll
enough.
be outdated by
Yeah,
then.
no, hang on.
Okay.
What is important is that you must be in status when you filed the form and they received the form. After that, if you file out of status, that's irrelevant. That doesn't matter.
Got it. And so if my 60-day grace period expires, I will not accrue unlawful presence because my L2 has been filed.
And that's right. That's called
Is that correct?
That's called authorized period of stay. Exactly. When you file the timely extension or change of status, even if the current status expires, you are maintaining authorized period of stay. You are not illegal. Okay.
Got it. And all I need is that receipt, right?
That is correct. I'm going to have to go on to the next
So
question.
I just need that receipt.
Yeah, sir.
Okay.
I've got to go. Good luck. Next one is also from Texas. Go ahead, please. You had some question or comment?
Hi, Rajiv. This is Manju.
Ji.
I got my EAD and assistant approved based on my company I-140 that was filed. Can you please suggest what would be the next steps for my company to after this? Should my company hire me immediately, or it should wait for I-140, or are there any other steps that my company should take?
I have no idea what you're asking me. I'm going to put you at the end of the line because I'm still covering the questions that are posted. Time permitting, I will answer your question. It's not related to anything I've discussed so far. Okay, so hold tight. We'll get to it. Okay, let's go. Anybody who's logged in right now, even if you have not posted the question, I will respond to your questions. We'll have enough time, no problem. But let me finish in an orderly manner. First, the questions that have been posted. So let's see, going up to, and I'll actually lock the conference room in about 7-8 minutes so that we can deal with all the questions that are already here. So the first question was from Karma Yogi that says, I'm trying to fix a USCIS typographical error, and the online form says the first name and the last name and the middle initial, but this is for the company. Well, first of all, when you are trying to correct the error on an H1B, that's not your case. That's your employer's case. Similarly, if there's a typo on an I-140, that's not your case. That's your employer's case. If there's an error on an I-485, that's your case, not your employer's case. So what needs to happen is your lawyers or your employer's lawyers or your employer themselves should call USCIS customer service. If it was premium processing, they should email premium processing center or premium processing office within the center and inform them there is a typo, and they usually send by email or by fax a fresh approval. If they have to call customer service, then the customer service will take the necessary information and somebody will call you back. So that's how it works. Okay. This is not your form. You can't get it corrected. Even if it is the petitioner's first name, last name, we recently filed an H1B. There was a typographical error in the petitioner's name. Yeah, your employer has to get it corrected. Okay, not you. *5 if you have a follow-up question on this. No new questions. Any follow-up question on what I talked about? Okay. All right. I'll lock the conference in about 6 minutes. We'll have enough time to answer everyone's questions. Let me go through the posted questions first. I've already dealt with Anusha's question. Next question, which is question number 4, converting F visa to EB1 and adjustment of status. I am on F1, husband is on F2. I'm looking to proceed with EB1 for my husband as he's a cinematographer in India, working for the last 10 years. I'm pretty sure you've spoken with me. I think I've looked at your husband's resume. Is it a common approach for someone from the film industry to do so? Yeah. We've done some EB1s for people in the film industry, music industry, entertainment business. We've done for script writers, even journalists. So yeah, sure. Our charges, our fees are actually on our website. So if you go to immigration.com, on the very top bar, the gray bar, there is information about us, etc. And fees is one of them. Click on that, it tells you what the fees is. I would also like to know whether you specialize in EB1. First of all, in Virginia and probably in most other jurisdictions, it is unethical for a lawyer to say they specialize in immigration, much less they specialize in EB1. It's unethical because you don't specialize, you can only focus. Is our practice focused on EB1? No. Our practice is focused on employment and business-based immigration. That includes EB1. We have done hundreds of these cases, but we don't specialize. We focus our practice in business and employment immigration. Will there be an adjustment of status charges? Of course. It's all written down on our fees page. So if you go take a look at it, and if you have any questions, feel free to send us an email. Okay. *5 if you have a follow-up question on this. Press *5. All right. Next question I've already dealt with. That was a frequently asked question. Next one also I've dealt with. It's a frequently asked question. Next one also I've dealt with, frequently asked question. Then comes question number 8. Traveling to other countries while in the United States on a B1, B2. So the question is, I'm here on a B1, B2. If I go to Canada and come back, or I go to Mexico and come back, will I get another 6 months? And the answer is probably not. As far as I know, Customs and Border Protection has been inconsistent in this. Sometimes they'll give you 6 months again, but most times they will not. Okay. Is it considered a new entry? No, I think that's irrelevant. I don't think they'll extend your I-94. I know the 30-day rule before your I-94 expires is considered as automatic revalidation. I'm not aware of any such rule. Automatic revalidation, AVR, is something totally different. I don't think it has anything to do with this situation. Okay. So, but the bottom line is, if you exit on a tourist visa and you re-enter, it's not assured that you will get another 6 months. I don't think you will. *5 if you have follow-up question. Press *5. Okay. Let's see. Green card holder getting married to a tourist visa holder. I'm planning to marry a girl from India who has a B1, B2 visa for another 3 years. After marriage, can she enter on B1 and file green card application? Oh, no. That's a problem. Okay, let me lock the conference because I think we have enough people here. I'm just going to lock the conference.
The conference is now locked.
Okay, just be assured, anybody who's here, I will answer your questions before we hang up. But I'm just going over the posted questions first. Okay. So here is the problem. You go and get married in India. Then you come, the green card holder, come back, and your wife tries to come in on a B1. First of all, when they enter, it's probably a lie, right? Because you're not coming in for a short visit, you're coming to convert to a green card. that will be considered to be a fraud. And if the government wants to be tough about it, they can bar you from entering the United States forever. That's a pretty serious matter. Don't do that. Okay. *5 if you have a follow-up question. And the proper thing to do is to apply for a green card for her and then wait outside the United States for a few months with her, but not too long so that you don't lose your own green card. But you can, of course, apply for a tourist visa again, or you can even visit as long as you tell them the truth that I'm going to visit my husband, my green card is pending, but I'm going to not stay beyond 6 months. I'll go back. And if they let you enter, you could do your entry in Abu Dhabi instead of all the way in USA. As long as you disclose the truth that you're coming to visit and don't convert to a green card, which is adjustment of status, you are okay. So this is California. California has a question. California, go ahead, please. I can hear you.
Question is whether we can come before a marriage and get married here on when she is on tourist visa.
You can get married and leave, but you can't stay here and convert to green card. That could be a problem. Okay. I had a case in which
Okay, she cannot enter.
she can come, enter, get married and leave, but she cannot enter and change to green card.
Okay, she cannot. When she come in, she cannot apply for adjustment of status. Correct?
Exactly. You can apply for I-130, but don't apply for adjustment of status. Okay.
Okay. Okay.
Good luck, sir.
You can apply I-130, but
Not
485
I-485.
can be done only after I-130 approved in I-485 approved.
No. What you will do is when you file the
After the
I-130,
approval of
when you file the I-130, you will mark on the I-130 consular processing so that the file gets sent to India to the consulate.
Okay.
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 Good luck and congratulations.
And in between, she can come on the.
If they let her come,
She can come on the.
if they let her come, be truthful. Tell them she's going to go visit her husband.
Okay.
Okay. If they let you enter, great. If they don't, turn back and you can do it from Abu Dhabi. That's what I just told you. Okay.
Okay.
Abu Dhabi has US immigration pre-clearance. So you can actually pre-clear in Abu Dhabi.
Okay.
If they let you enter, great. If they don't, come back. Don't lie to them. Be absolutely truthful. Okay.
Okay. Okay.
Good luck. Okay. Next question. This is number 10. Permanent resident of Canada getting married on a tourist visa in the US. Oh, we just were talking about that. I'm a permanent resident of Canada, living in British Columbia, Canada. Girlfriend has been waiting for her asylum. Can I go to the USA with B1, B2 and marry her? Yes. If you get married and go back to Canada, that's perfectly legal. I don't think this is a problem. I don't know anything about the asylum laws. You may want to check with her lawyers who are doing the political asylum. I don't know how that works. But as far as getting married on a tourist visa is concerned, that's fine. And by the way, when you enter the United States or when you apply for a tourist visa, you should tell the consulate and you should tell the port of entry, I'm going to go get married and come back. If they don't let you come, that's a totally different problem. But if they let you come, that's the way you should. You should not lie to them at the port or during obtaining the visa. If I can marry her with my B1, B2, yeah, I don't know anything about asylum. That you have to check with her lawyers. Yeah. So I think I've covered most of your questions. I can't think anything I've left out. *5 if you have a follow-up question. If you are here, press *5 please. Okay. USCIS handling of H-4 EAD premium processing. There is no H-4 premium processing. And they have not yet started H4 EAD premium processing either. It's there in the books, but they haven't started. My previous H4 was valid till May 2022, according to my husband's H1 expiration. I was working on H4 EAD, which was good till May 2022. Sir, don't be that late in raising your hand. I'm in the middle of the next question now already. Please be quick about raising your hand. Okay, Texas, go ahead. What is your question?
Yes, so I am recently being laid off from a company.
Okay,
and
hang on. This has nothing to do with what I'm talking about right now. So wait till the end. I'll call for new questions. Only bring up questions, either you have posted the question or you have a follow-up on what we are discussing. This has nothing to do with that. So sit tight. We'll come to you. Okay, we already covered this. H4 EAD premium processing. Now, husband's H1 extension was filed by his employer. It got approved, granted till Feb 2025. He wanted to take a new job and transfer was filed for him in 2021. The transfer was approved, December 2024 validity. My H4 and H4 EAD extensions were filed using the receipt number of the transfer, but he later decided not to take up the new employment. As a result, my H4 and H4 EAD extensions were later filed using his current employer. I think you can keep the H4 and H4 EAD transfer petition filing. Yeah, I think you can keep those. One good way to handle this is, because this all gotten very jumbled up. See, this is the basic principle. It is the H1 holder who has to maintain status. Everything that the H4 does depends upon the H1 holder. Okay? The fact that they are with employer X, Y, Z, A, B, C doesn't matter. Your H4 does not depend upon your husband's employer. It depends upon your husband's status. So in my view, your EAD is fine, your H4 is fine. But in order for you to just be sure that there are no other issues, tagline issues, just go ahead and have your lawyers contact the USCIS customer service. Speak with them. I don't see any problem. You got your H1B visa stamped. Yeah, I think it's all fine. Yeah, I think it's all fine. Star 5, if you have a follow-up question, you can always contact the USCIS customer service to confirm, but I don't see any problem. So this one is area code 848. Let's see. 848 is New Jersey. Okay, New Jersey, go ahead, please.
Rajiv ji, good afternoon.
Good afternoon, sir.
Actually, the problem here is that the H4 EAD and the H4 filed with the transfer petition, right? They were approved. But what happened is the expiration date on those is not according to the end date of the transfer. It is according to the end date of my current petition.
Hang on. I already saw that. I don't worry about that. Which is, you said it's Feb 2025 instead of December 2024, right?
Right.
I don't care about that.
Even if
I don't care about that.
Even if I did not take up the job, right? So she has no issues using that EAD.
I don't see any problem with that. Remember what I told you, the principle is H4 does not depend upon the husband's employer, which is you. H4 depends upon the husband's status. Okay? If they gave you a couple of months extra, that's their fault, not yours. But in order for the paperwork to be kept straight, I always have my office, our team, call the USCIS, talk to the customer service, write down what they told me, put down the date, put down the name of the officer. They either give you the first name of the officer or they give you the badge number. So you put that down and that's the end of the story. I don't see any problem here. Okay? Sir?
Yeah, actually, we called them, Rajivji, but there was no proper
Have your
response,
yeah.
and they told us
No.
they told us actually to wait for the other EAD to be approved.
No, I don't agree. You call US. You have your lawyers call USCIS. They will talk to an adjudications officer rather than the first line staff. The frontline staff is very ill informed.
Okay.
You need to talk to a service officer. Okay. Good luck.
Okay.
Yeah.
Okay.
I disagree.
Thank you so much.
You're welcome. Yeah, I completely disagree. Why shouldn't you use it? They've approved it. Okay, next question is number 12. Can a student on OPT enroll in an online or offline course? My question is a follow-up from the previous conference. I asked if master's degree student working 20 hours part-time, maintaining OPT, can in parallel study? Absolutely. My University International Student Office denies this and says enrolling in any course, you know what? I may be wrong because the university is an expert. What should you do? How do we confirm this? See, I have to look at the regulations. Personally, I don't think why it should be a problem. If you are working on OPT, why can't you take courses at the same time? If you're on a student visa, let's take another example. Let's say you're on a student visa and you are taking full-time courses in one college and you want to take another part-time course in excess of your existing full-time workload. Can you do it? I think you can. So how do we find out? Here is what you should do. First, call SEVIP. Okay? SEVIP officers are actually pretty informative. They can answer your questions. So call SEVP. Call SEVIP, talk to one of their officers, explain the problem, tell them what they say. And by the way, let me know what they say. You can email me at help@immigration.com. help@immigration.com. Okay? So I think you should be able to. But if the school says so, they are supposed to be the experts because they manage your service. So I think they're wrong. Okay. *5 if you have a follow-up question on this. *5. Okay. Then next question number 13. Nev says continuous residence and physical presence for naturalization. I became a green card holder 2018. Got a 1-year re-entry permit. Started college in August next year, 2019. I'll be completing 2.5 years, which is 913 days. April 30th, 2023. I was stuck in India for about 9 months. Yeah, I think that should be all right because there's a reason for it. Yeah, I think you should be all right. You can apply 90 days prior. Yes, I believe so. Absolutely. How do we explain the 9-month absence? Provide proof. Will Rajiv be able to help out? If you want us to, sure. I'm not sure you need a lawyer for this, but that's what you prefer. We'll be happy to assist. What are the chances? The explanation will be accepted. Hey, if we can prove that it was not advisable for you to travel because of health reasons, I don't see any problem. Do I need to be in the same state for a few months prior to at the time of applying for naturalization? You must be domiciled in the state for at least 90 days. Can I leave the country after making the application? Just for a few days. Yeah, you have to wait for the fingerprinting. Yeah. Even after naturalization, one has to maintain the 6-month absence. Yes. Oh, not after. No, sorry. Not after naturalization. During naturalization. So if your application is pending, you still should be gone for less than 6 months. And you must not sever ties with the United States. Okay. After applying, how many months citizenship is granted? You can check the General Times online. Just Google USCIS processing times, and it will tell you select the form. You select the form N400. Select the office where you will be interviewing. Let's say, for example, LA, and it will tell you the approximate time. Okay. *5 if you have a follow-up question. Okay, we'll be starting new questions soon. Follow-up question looks like India. Go ahead, I can hear you.
Yeah, Rajiv, the question here is, given that you said that one can apply 90 days prior, what is the earliest we can apply for this, keeping the 2.5? Then when can we approach you to file the paperwork?
So like I told you, 90 days before your eligibility. Okay. So if you become eligible, let's say with your 2.5 years in January, February, March. In March, we can apply in January, which is 90 days ahead of time. Okay. But you must already be domiciled in that state for 90 days. There used to be a rule. What the government used to do was they would let me apply and use the 90 days towards your domicile also. They're not doing that anymore. I can double check, but my understanding is you have to be domiciled in the state for 90 days. And if you are then so domiciled, then you can apply 90 days ahead of time. But if you are not domiciled for 90 days, you have to wait until you are domiciled for 90 days. Make sense?
Right, makes sense. In this particular case, have been in a certain state for last 90 days. So I suppose that should be all right.
That should be all right. Now you can apply 90 days ahead of time.
Okay, excellent. Thank you.
All right. You're welcome. Good luck. Okay, next question. I believe this is last two questions. Okay. Misdemeanor convictions and immigration outcomes. Unsafe lane change. It's a misdemeanor. Okay, so you're asking me different sorts of questions. The normal rule is one misdemeanor where the sentence actually imposed is less than 6 months or none should have no impact on your green card. Does it have an impact on your job? I don't know. That depends upon the employer. Is it worth defending it in the court? I don't know. If you have a case, you can definitely fight it. But that's really not something I can comment on in the abstract. Is it worth fighting? And that's not something I don't have the information on that. If you want more guidance, I would recommend, this happened in Nevada, get in touch with two lawyers. One, somebody who specializes in or focuses in traffic violations. And second, somebody who focuses their practice on deportation or removal defense. Why? Because they will know all the local statutes. It's unethical for a lawyer who's not admitted in Nevada to talk about Nevada laws. I can talk about generalities, but to get somebody local who does this day in, day out would be the best thing. So get those two lawyers involved. Even if you end up paying a few $100s more, I think it'll be worth it. It'll be worth your while. Okay. *5. If you have a follow-up question on this, press *5. Okay, we'll be starting new questions after this one. The last question is, how can an international student become a licensed pharmacist? Okay, so I don't remember all the pharmacy admission rules, but you already know that. You need 1,500 hours of clinical experience. Now, because I'm an F1 student visa, it does not directly relate to pharmacist jobs. I want to get pharmacist experience. Have you talked to your DSO? Are you on the phone? Press *5 if you are here. Press *5 if you are here. Okay. So I would talk to the DSO and I would say that, health informatics and pharmacy, see if they can offer you, the pharmacy can offer you a job that includes both informatics as well as pharmacist experience. I can't think of any other way you can do it. I see you have a catch-22 situation. There are jobs like informatics pharmacist, but there must be something which is like an informatic pharmacist intern, where you are not working with patients, but you are working under the direct supervision of a pharmacist. I don't know what the state laws on this are, but that's normally how we do for H-1Bs. So instead of working as a pharmacist, you don't deal with people. Instead, you become an assistant who deals with the pharmacist. And that way you can be an intern informatics pharmacist. So talking with the DSO and an intern job are the only two things I can think of. *5 if anyone has a follow-up question on this. Okay, anyone has any question on any issue, please press *5 and I will call you in the order you logged into the call. Anyone who has any question? So far we have 5 people, 6 people, okay, 6 people with questions. I'm going to begin with Cleveland, Texas, who joined the call first. Cleveland, I can hear you. Go ahead, please. Texas, I can hear you.
Hi, Rajiv.
Yes, hello, ma'am. Go ahead, ma'am.
Hello?
Yeah, go ahead.
Yes, sir. I filed for I-140 in EB1C category, and I got my EAD and SSN, and I-140 was filed by my company. I wanted to know what are the next steps for my company to take. Can it hire me right away, or should it wait for I-140 approval?
Okay. Are you currently in the United States on an L1A visa, ma'am? Or are you here on a tourist visa?
I'm on B1, sir, business visa.
Business visa. Okay. So they cannot hire you until you file your I-485 and you get your employment authorization. Okay? Because
Yes,
B1...
sir, I got it. My 485 is filed and EAD is employment authorization.
Oh, so you got it. You got your EAD. Okay, I'm sorry, I missed that part. My apologies. So you got your EAD.
Yes, sir.
You've got your social security number. You can
Yes,
start
sir.
working right now if you want. No problem.
Is there any documentation like I-9 or something that has to be filed?
Yeah,
with the
that's the
company
company
or any
HR
other
procedures.
that has to...
Yeah, they have to do all that. But those are internal processes. That has nothing to do with any filings that you need to do. Okay?
Yeah, because the company is my own company. I just wanted to be sure of the processes that are involved.
Yeah, you have to. In the United States, there's actually an employer's handbook on I-9 on the USCIS website. You can download that. It tells you exactly what the HR must do for every employee they hire. Whether they are a US citizen, green card holder, or an L1 or an EB1. My concern is your conversion to B1 to EB1C. I don't like that. I don't know who gave you that advice, but I'm not going to comment on that. As far as your question about starting work is concerned, you are ready to start now. How to fill the I-9 and all, you download the employer's handbook from USCIS website. Okay?
Okay, sir. Any other process to be followed or any other forms to be filled other than I-9?
No, that's it. Okay?
Okay, sir. Thank you. Thanks a lot.
You're welcome. Okay, let's go on to New Jersey, Vineland, New Jersey. New Jersey, go ahead, I can hear you. New Jersey.
Hey, sir.
Hello, sir.
Yeah, I was on the last call as well. And basically, I inquired about filing EB5 for my sister who is on F1 visa here.
Okay.
And I am doing, like, right now, extensive research with speaking with a lot of developers.
Right.
And other EB5 regional centers.
Right.
And right now, my confidence level is, 50%. Other option I'm exploring is maybe buy a hotel and with partnership with someone and then go with that. So all in all, few questions before, exploring EB5. I want to schedule a call with you as well, which I will start today with the paperwork. But if I want to know, like, if it makes sense to file EB5 because the travel document takes like up to 20 months to get based on USCIS processing time.
Yeah.
And she's on F1 visa, and whether she should leave the country, get F1 stamp again, because she's on OPT EAD. So I don't know if they will give her F1 visa on OPT EAD, or because he has been 9 years, he hasn't left the country.
No. Okay, so leaving aside the EB5 issues, some of which I may be able to answer, some not, because I don't have enough information. Bottom line is, if somebody is on OPT and they want to get a new visa, it's always risky. There's no guarantee that she will get a visa stamp. I actually had somebody who got denied in PhD 5th year a student visa, somebody from Rajasthan. That lady was very lucky. She was able to finish her PhD from India, but they denied her visa in the 5th year on OPT. She was on 5th year of PhD and she was doing her pre-completion OPT. They denied her visa. So that's always dangerous. There may be other options. I like the L1 visa a lot. So if you have an active business in India, bring your sister home, let her be the manager. Let her be a manager or an executive in the company. Open a branch of that company. Remember, the company in India and company in USA can be doing completely different business. So let's say in India you are a manufacturing company. In India you are a manufacturing company. In USA you could be a hotel owner, and still transfer her on L1. The EB1C green card is approved within a year and a half, and it requires no particular investment. It requires only a business. So
Can she?
Go ahead. Go ahead, sir.
So with L1, so how these two companies has to be affiliated?
Yeah, that's a long discussion. That's a long discussion. We can do it separately in a consultation. You can send me an email to help@immigration.com. Put all the questions that you can think of in there so I can assess the time needed for the call.
Sure.
Also, just to give you a quick rundown, the way it works is she has to work outside the United States for 1 year as an executive or a manager for a company. Let's call it a company. A company must be related to B company in USA. And how can the relationship be established? You could have B company own 51% stock of A company, or A company own 51% stock of B company, or both A and B owned by a mother company, or the same majority stockholder in both companies, or the same group of individuals with similar stock holdings in both companies. There are many ways to do this. So
I see. So there should be ownership interest.
There should be equity interest should be there. We can do it through veto and control also, but that's very complicated. And there is always a chance that government is not going to buy into that. Equity is the better way to do it.
Can she stay? Can she stay in Canada and operate?
Yes, sure.
Their India business.
Well, if it is possible to do so, but I'll tell you this: we have many high-tech companies who have actually opened offices in Canada for some of their senior technical people, and we have done a bunch of those green cards, EB1C, L1 green cards. So the country is not important, the business is. Can she run business in India sitting in Canada? If it is possible to do so, sure, why not? I see no law against it. Okay. So we'll talk. You can just send me an email.
And one last question. Well, if she goes with this EB5 route, and her I-485 is pending, and let's say during this period she marries someone from India, or whether here or there, can that person become part of 485?
Not 485, but they can become a part of the green card. So that person would have no way to come to the United States. So
let's say the person is here.
If the person is here on a valid visa, not tourist visa, let's say student visa or H1B, L1, They can, yes, they can definitely become a part. We can file her for his 4485 also, no problem.
Okay. After her 45 was filed, like later.
After or same
till her
time.
application filed, right?
After or same time.
After the same time. Okay.
Yeah. If they are married.
All right. So thank you. I will. Yep. So I will send a list of. I will compile a list of
हाँ जी,
questions.
no problem. I'll take a
Can
look
we
at
have
them.
that immigration.com?
Ji.
And
I'll set up a call for us.
okay. And sir, can you? Yeah. Sir, can you do in person or just video is the best?
I have not done in-person appointments all through COVID. In our office right now, there are only 3 people working. 30 of us are working offline.
Okay.
So we can do a Zoom call if that makes you more comfortable. Okay.
Okay.
Good luck.
Thank you.
All right, bye-bye. Okay, so let's go to we have 4 questions remaining. Let's go to Texas. Texas, I can hear you. Please go ahead.
Yeah, hello, sir. My
Hello.
visa status in USA is H1B.
Okay.
And I have a couple of questions with respect to that.
Sure.
So I got laid off a couple of days back on
Okay.
H1B.
Okay.
My couple of questions are, if I get my I-797 initial notice approval from any other employer, after, let's say, 60 days, then shall I be eligible for H1B or for H1B and to stay in USA after 60 days if I get my initial notice?
Okay, so hang on. Let me stop you there. So the law is your application for H1B transfer, your petition, must be received by the USCIS within 60 days. There's no law that it must be approved within 60 days. So let's say you got laid off today. You have 60 days to have your second case reach the USCIS. Once it reaches the USCIS, you can start working for the new employer, even while it is pending. Okay?
Okay, so which means the employer should be sending the case to the USCIS within 60 days.
Correct. Not sending. You should be sending. Hang on. Let me correct it. You should be sending it so that it reaches USCIS within 60 days. If you send the case on the 60th day, it will.
I cannot send. Only the
employer
can.
can.
Employer can
Yeah,
send,
of course.
Right?
Of course.
Okay.
So the idea is, if the employer sends the case on the 60th day, it gets there 61st day, you are out of status. But if they send it on the 59th day and it gets there on the 60th day, you are okay.
What if they send after on the 60th day and USCIS receive it on, let's say, 63 or 64? Then what shall be the scenario?
If the case gets there after 60 days, you'll have to go outside for visa stamping, and you cannot start working until you get a visa and come back. Of course, USCIS can choose to forgive your 1 day, but you cannot start working until they decide your case. Okay?
All right. And if I receive if my case receives to USCIS on the 60th day, then will I be eligible to stay in USA further?
Absolutely. Not only eligible to stay, you are eligible to start working.
All right. Yeah.
All right.
All right. Thank you, sir.
You're welcome. Good luck. Okay, let's go to the 3 more people remaining. Let's go to Illinois. Illinois, I can hear you. Go ahead, please. Illinois. So Illinois, then Wisconsin, then Michigan. Illinois, I can hear you. Area code 312. Okay. Illinois, I can hear you.
Hello.
Yeah, go ahead, please.
Yeah, can you hear me?
Yes, I can. Go ahead, sir.
Hey, Rajiv. Thanks. Yeah. So I had reached you out on LinkedIn, but I didn't get a chance to kind of explain my situation.
Okay.
So I was on a day one CPD program for a few years, working for my employer
Okay.
on a F1, and then they have been filing for H1B, which got approved this year,
Okay.
and I had a RFE as
Okay.
well, which also for maintenance of status, which got cleared.
Okay.
So
Good.
my employer had filed for a change of status, I-797A, but that part got denied, and I got I-797B.
Okay.
And with that I-797B,
Okay.
they also sent a separate document called a decision document,
Okay.
in which they explained why my change of status was denied. So they basically had asked me in the RFE documentation all of the pay stubs in that period where the maintenance of status was in question. And I did provide that, and they noticed a couple of pay periods, where basically the employer paid me when there was a gap. So I was changing degrees between my first master's on day one CPD and second, and then the second and PhD. And that's where, my employer paid me. But so basically what USCIS is saying is that I did not maintain status for a total of 29 days in those two periods. And that's why I've engaged in unauthorized employment, and that's why they are sending a 797B. I did not actually work in those pay periods, but there was an administrative error on my employer's part where, they paid the salary. So my question is, what are my chances? I will obviously go to the consulate in India to get this stamped.
Okay.
But,
Okay, hang on. Hang
my
on.
DS-160.
Hang on. Hang on.
Yeah.
Hang on. Let me tell you what the law is. Visa stamping is a procedure through which you take care of all these irregularities. So that procedure is meant to be a solution to these problems. I don't think you're going to have any problem in the consulate because of this. Okay? Number one. And be absolutely truthful. Don't lie about anything. If you lie, you are in trouble. If you work without authorization, tell them I work without authorization.
Okay.
Sorry. Okay? And remember, you don't have to go to India. You can go to any consulate anywhere in the world. You could go to Jamaica, Bahamas, Costa Rica, Mexico, Canada, anywhere you can get an appointment.
Okay.
Okay. Of course, you can get delayed there. Be prepared to stay there if necessary, or travel to withdraw your application for visa and travel to India if you prefer. But there's no requirement that you have to go to India to get the visa stamping. So two things you take away today. One, visa is the cure to these problems. Don't ever lie about it. Be absolutely upfront. Two, you can go to any country. Okay.
Okay.
Anything else?
Okay. And Rajiv, Rajiv. So in the DS-160 where there's a violation question, I'll obviously say yes to that.
Yes.
It does open up a box for explanation.
So what?
Where I have put
you put down. You put down whatever the truth is. Don't try to embellish the facts. Be brutally truthful. That yes, I worked without authorization, or no, I worked without authorization, but it was an administrative issue. I should not have been paid for that time, but I was. But if that's not the truth, don't put it like that. Put it the way it was. Just say that I worked without authorization.
Okay.
Okay.
Sure. And I'm currently on the F1 visa. So what happened was my service record got terminated. But I did reach out to my DSO, and they said if it's consular notification, they can reinstate the service record. Otherwise, I have to depart immediately. So I just wanted to check if they are able to. My DSO has currently talked to service to get the service record updated.
Hang on.
Back to being active.
Hang on. Back up a little bit. When you applied for an H-1B, were you in CPT or OPT?
I was in a day one CPT program.
Okay. So what the DSO is saying, that they can revive your service, that doesn't make any sense. Because your service
No,
should
they're
not.
saying, so what happened is,
Go ahead.
mhm.
Go ahead.
Yeah, my service became inactive. My service became inactive the moment I got the H-1B
Change of
approval.
status. Okay.
So they're
Yeah.
saying they can keep.
Yeah.
Yeah.
I
So
would
they're saying they can make the service active.
listen. If they can make the service active, you still have the problem where the government has found you to be out of status. I think your best bet is to go get your visa stamping and
Yeah.
come back. Okay. Go get your visa stamping and come back.
Okay.
All
So
right.
I'll try to leave immediately in that
Yeah.
case.
And
Okay.
it doesn't have to
And
be,
then my
doesn't
last
have to
question,
be,
Rajiv,
hang on, sir.
Hmm.
It doesn't have to be today. Over the next week, 10 days, just leave.
Okay.
Go get your visa stamping done wherever you can.
Okay.
And if you tell the truth to all questions asked, they might delay you, but they cannot deny you.
Okay. And should I do a drop-off or an interview in this case?
Yes, why not?
Opt for.
Yeah, your visa
Okay.
was never cancelled.
So interview.
Yeah, your visa was never cancelled.
Okay.
Yeah, you can do Dropbox. Okay.
Sure.
Good luck.
Okay. And then lastly, should I, Rajiv, should I take any proofs for that period where I actually did not work? I was on a trip here locally in the US. So I have like hotel bills, flight tickets, all
Absolutely.
of that. So do you think the consular officer, okay.
Well,
And
because
would it make sense
see,
if my employer kind of issued me a letter?
yes, if they put you in administrative processing at the consulate, they give you a 221G, all these documents will help you, including
Okay.
because they can't stop you for unauthorized employment, but if you have given an explanation, they might want to look into it, even though it has no bearing on your case. Visa has to be granted even if you violated status.
Sure.
Okay. So yeah,
Okay.
take the
Makes
documents.
sense. Thank you.
Absolutely. Good luck. I'm not worried about this case. It will get resolved. As long as you tell the truth at the consulate, don't try to keep anything back. Okay?
Okay. Thanks a lot. I really appreciate Rajiv,
You're
your
welcome.
advice.
You're welcome. Good luck. Okay. Let's last two questions. Wisconsin. Wisconsin, I can hear you. Go ahead, please.
Hello. Hi, Rajiv. My case is that I am currently on L1B,
Okay.
but during the window of H1B lottery, my H1B got picked up by the different employer.
Okay.
And my case, H1B approval is still, it's showing as, it's being in review actively.
Okay.
At the USCIS site. So I reached out to my employer and asked them, can they, change that visa process, H1B visa processing to premium? But they said in my case, the premium processing does not apply. So is that true?
No, that's not true. Premium processing applies. What you can do is, you can tell them that under the law, I'm allowed to pay the premium processing fees. You don't have to pay it. If you let me pay the fees, please go ahead and premium process my case. Okay.
Okay.
Because when
Thank you. That was all.
Thank you so much. When the premium processing is being done for the convenience of the employee, at the request of the employee can pay. Okay.
Okay.
So that should take care of the
They
problem.
were saying that, since I've been hired for a new position and the project is, I'm not sure the project is going to start and something. So
Okay,
in that case,
now that's a
USCIS
different
does not
that's a
consider
different
premium
thing. If they don't have a job for you, that's a different thing. But you are entitled to premium processing. No question about that. Okay.
Okay.
Good luck.
Can I do it myself or I have to go through
No,
an
no,
employer?
you have to go through them. You can do nothing in the case.
Okay. Thank you so much.
Good luck, sir. Okay. So the last question is from Michigan. Michigan, go ahead. I can hear you.
Yeah. Hi, Rajiv.
Hello, sir.
I had previously got in touch with you on LinkedIn.
Okay.
So my case, currently I'm on F1 STEM OPT and my case was approved for H1B under consular processing. I'm looking to switch jobs, and a couple of employers that I got in touch with, they said that my H-1B cannot be transferred because of consular processing. They say that I do not have an H-1B, and they because I do not have an H-1B, a lottery pickup cannot be transferred. So I don't know what proof or evidence I can show them or tell them to transfer them. I got the information from you that it could work out, and I also asked a couple of other immigration lawyers on public forum platforms. They also confirmed that this can be transferred. But yeah, I don't know how to handle
here is the problem. Was your H-1B approved for consular processing or with change of status?
Consular processing. So I had an emergency travel
Hang on.
before my petition could be filed.
Hang on. Okay. So here is the problem. USCIS has said in various conferences that they don't consider the H-1B process to be complete until either you received change of status or H-1B visa stamping. Okay. I heard it. I looked at the rules. I didn't see that there was a clear indication that's what is required, because the regulations all talk about H-1B approval. They don't talk about change of status or visa stamping. So we went ahead and filed a bunch of cases like this, and we've always gotten approvals. So now the problem is not with doability, the problem is with willingness. If the employer is willing to try, maybe they'll lose their money, but if they are willing to try, I think it could work out. Worth a shot. Okay?
Okay, yeah, because I don't know what proof or even situations that I've seen on Facebook groups as well, that people were able to do this. But yeah, I like you said, it's depending upon the willingness of the employer.
Yeah, because naturally the employer is concerned about wasting their money. Okay. But at the same time, if they need your services, a few $1,000s is actually a very good investment. Okay.
All right. Okay.
Good luck.
I'll see if I can try to.
Yeah, try to convince. Yeah, try to convince. You can even play a copy of this call will be available online. You can play them this part and say, look, I've talked to Rajiv and he said that. We do it all the time. Seems to be working out so far. What they say and what they do at the USCIS are two different things. So far we've been successful. I think it's worth trying. Okay.
All right. Okay.
Good luck.
Thank you very much, Rajiv.
You're welcome.
Yeah.
All right, folks. Good talking to all of you. I'll see you again in 2 weeks. Happy holidays and stay well, folks.